Good afternoon, everybody. Thank you for joining us. Got kind of a fun topic here, less legal density and more practical concepts, things that we deal with quite often. Doesn't matter, good economy, bad economy. We are regularly seeing partnerships with issues, and we like to catch those ahead of time before we devolve into the litigation process. But sometimes we're able to do that, and sometimes it doesn't happen, and we get into litigation or in pre-litigation, and the breakup is imminent. This can be in the family context. I've seen this often and have dealt with some situations in the domestic courts where there's a split up, and then the folks splitting, the spouses own a business or have business interests and split it up. But even more often, it happens just in the regular business context, medical practices, law practices, accounting. Again, when the economy is good, things are going well. Sometimes there's different interests on which direction a business should go. When things are bad or if business isn't doing well, then there's a lot of blame being passed around. And we have a breakup. And the breakups are, I call them business divorces. I'm not the only one. And these are situations, it's a partnership breakup or shareholders are leaving. And we're going to talk about that today and some of the tactics that are used in negotiations and in mediations, and how we can work towards a resolution without destroying the golden egg, if that be the case, or destroying the relationships for the long term. So our agenda up on the screen here is we're going to talk about a little bit of the anatomy of a business divorce, what brings it about, what are the common scenarios that we see. We'll talk about some issues that make business divorces unique versus other dispute scenarios. And then we're going to talk about how to start the negotiation, how to get that process started, and then how to essentially get the parties talking, try to avoid destroying the relationships, which often happens in a knockdown, drag out lawsuit. Either hit that process early or before legal action is taken, maybe even negotiating in a mechanism or a method to save the business. So you don't, maybe you're able to keep the business and parties keep their business interests. There's all kinds of creative ways. Sometimes both people stay involved or use the business name and split off and run different operations. We'll talk about some of those different options and again, things that make this particular scenario unique yet common. When we're in negotiations, sometimes things can get heated and intense, especially if you're dealing with somebody who's known to be difficult, whether that be a business partner or a lawyer. Certain people have a reputation for being difficult to deal with. And then, of course, there's dirty tactics, and we'll talk about some of those. There may be a time and a place where you implement some of those as a manipulation tactic, but really if we're working towards resolution, we want to understand when we see those and how to overcome those tactics, and we're going to talk about that. There's a lot of material on the slides. If you have any questions, please do reach out to me after the webinar or during the webinar. We'll leave question and answer time a little bit at the end if we can. I may skip over a few where things are, to emphasize things that are more important, but without further ado, let's jump into part one, which is the background of the business divorce. And these situations, people get in business together via, we see a medical practice, or maybe, shareholders that invest in real estate together, a construction company, accounting firms, all different types of businesses. And often they come together similar to newlyweds. They may have been introduced to each other, meet in college, work together at a particular company. It could be a mentor-mentee type relationship where somebody's working for somebody else who leaves. You see that a lot in the law firm context. The senior partner leaves a firm, and a large firm, and maybe some of the junior folks follow along with that person. They often go into business together. A lot of times it's not well documented. We always, of course, recommend as lawyers that we have an operating agreement or a shareholder agreement, a partnership agreement, a set of governing documents for your business to deal with situations. Oftentimes you don't really need a lot of that when things are going well and everybody's on the same page. But what happens when you're not on the same page? And that's going to happen after the newlywed phase is over. You're going to have differences in opinion on how a business should operate. And if you have, what I like to do is have a shareholder agreement or an operating agreement that has very specific dispute resolution mechanisms that require the parties to negotiate and talk in good faith, meet face to face, perhaps have a cooling off period after a negotiation or a mediation before they engage in further action. Of course, you can put buy-sell provisions and other dispute resolution provisions. But even with buy-sell and with all the language that you put into an agreement, it doesn't necessarily stop the parties from engaging in a dispute. Buy-sell, we could disagree with appraisals, think that somebody's not acting in good faith. So the causes of the disputes can be anything from a view of disparate workloads, disparate benefits and compensation coming out of the business. Somebody's not pulling their fair share. Of course, a difference in the company vision and direction. And of course, if things get tough, this can lead to a lot of stress. We saw in the last economic downturn. Hopefully, we don't see that again for a while. But we did see, when things slow down, things that creates a lot of stress in a business, and people can try to lay blame for that, or they can try and perhaps maybe shed the business or shed each other of what they consider to be extra baggage in a business. And often if you have problems like that, they can seem insurmountable. And what we like to do is try and encourage folks to, stop, take a few deep breaths, and consider, why people got business together to begin with, and then try to work through. What you don't want to do is you don't want to destroy your business. I've seen, I've represented physicians who were in a breakup scenario and fighting over usage time in the surgery center, and canceling each other's appointments and shutting off the power for equipment. You don't want to get into that type of situation where you're sabotaging each other's business, because everybody can go from doing well, and when we can just split that up or figure out a fair way to operate for everybody, into a situation where now we're creating issues, potentially problems that can lead to third-party issues, regulatory issues, lawsuits for negligence or malpractice for professionals, failure to complete contracts for businesses, and ultimately maybe the failure of the business and killing the golden egg. So that's some of the stuff that makes a business divorce a little bit unique. Again, it's oftentimes very similar to a domestic divorce, but there's even more unique issues with the business divorce. You often have shareholders or partners that have certain rights under statutes or under the business documents. They also, what you have that's unique in this context are fiduciary duties. And those fiduciary duties create responsibilities where partners or directors or officers in a business, shareholders or members sometimes in a closely held business, not only should we act kindly to each other and act in good faith to each other, but you have a legal duty of loyalty under a fiduciary duty, a legal duty of care to a certain extent, not to do things to sabotage the business or to act in bad faith towards the people to whom you owe your duty, which is your other members or your partners. So that's a unique aspect that comes up. And if you see a business that's facing this situation, we can expect to see that if there's a lawsuit filed, one of the allegations in the lawsuit typically will be something that looks like a claim of breach of fiduciary duty. And no one ever, it's kind of like fraud. People do not want to be accused of breaching a fiduciary duty. This is something that can give rise to claims for damages, for punitive damages, business destruction. And once that lawsuit is filed, once the complaint goes out, there's allegations and there's things that are written in a very conclusory fashion in a lawsuit that we prefer to avoid. So if we can get in front of these issues, that's what we want to do. Talk about pre-suit settlement conferences. Again, as I mentioned, sometimes we'll put this in some governing documents. We'll require parties to negotiate or mediate a dispute. I will typically include this in contracts and operating agreements with multiple members, shareholder agreements, and other business contracts. We also will include that. Oftentimes I have it just in regular business contracts. If there's a consulting agreement or independent contractor arrangement between parties, I want them to talk and come, preferably face to face, and have a serious conversation, perhaps require them to engage in a mediation before they go on to a further dispute, and to prevent that situation where people show up and say, okay, we're going to walk out of the room and we're filing our lawsuit. They show up and they've got the lawsuit in their hand and they're ready to file it. We can write in requirements in business documents that you have a certain cooling off period, so that the parties must first meet face to face, either again in a negotiation or in a more formal mediation. And if there's no resolution, then at least 10 days must pass before either side can file a lawsuit. Pardon me as I get a little bit of water, and we'll keep this going. I want to also point out that as I have here on the slide, much like a domestic dispute, because of the nature of how people often get into business together, it starts as friendships. Again, spouses, friends, siblings, classmates. There's often background history before the business with the folks that are involved, and this also often leads to an emotional component. Even if there's not a lot of background, if you've ever started a business with somebody, people who've gone through that experience, pardon me, people who've gone through that experience know that you develop a sort of a bond with the people that you do that with. There's a kinship there. And this can often lead to sore feelings if people think that the other side is not being fair with them. And I'll point out too that I talk about a business divorce being analogous to a domestic divorce. One key distinction is that in domestic divorce, we're really looking at husband, wife, or a spouse. But in the business context, this could be a group of shareholders or a group of partners in a business. You can have say a medical practice with maybe 10 physicians, and maybe 3 of them are going to break off because they don't like the way the operation's being run. Or maybe you have a couple of them who are content, and then a larger contingent of them want to break away. And there's any number of reasons that can happen. But you do have another dynamic there, which would be where you can have multiple people all at the same time involved in a dispute. So as I talk about some of the concepts today, it dawned on me there's a ton of material that you can go out and read, both in the formal education process, and in academia, and just in the business world. And if you walk into a local bookstore or go online and look for audible audiobooks, some of the most common books that we see, and this is almost required reading for a lot of lawyers or anybody that goes to a formal negotiation training course, Getting to Yes. That's an older book. It still has very good concepts, and I'll talk about some of those concepts today. Getting Past No, one of the authors, William Ury, who wrote Getting to Yes, wrote this book later, and it deals with the situation. A lot of what we'll talk about today is, what if you have a party on the other side who doesn't want to engage in the type of negotiation that you want to engage in. And Getting Yes, they talk a lot about separating positions from interests, and get away from positional bargaining and talk about what somebody's interest is. The common example of that is the orange or the egg scenario. Use the orange if anyone's not familiar with that. You have 2 people fighting over an orange, and they ultimately decide to split their positions by each taking half the orange. Whereas one of them eats the orange and throws away the peel. The other one used the peel to bake a cake or cupcakes and throws away the insides, where both of them could have satisfied their interests had they explored it a little bit more. Very good concepts in Getting Yes, but then Getting Past No, the discussion focuses on, well, what if you have folks who just refuse to engage in that type of negotiation? And we see that a lot, again, because of the emotional component in the business divorce scenario. You see where people are dug into positions over sometimes what seem like very frivolous type demands. So we'll talk a little bit about how to deal with that. Some of the other materials we look at, difficult conversations. This was written by one of the folks at the Harvard program on negotiation, or a couple folks there. Interesting book. Never Split the Difference has been popular in pop culture. We see Chris Voss all over the place on YouTube, and has his own group that counsels people on negotiation. Some great concepts in that book. And then some of the other, negotiating the non-negotiable. So these are some of the sources that I pulled from. But what I've done differently here today, I think, is taken some of these concepts and shown where some of these they're great concepts for people if they adapt them to their needs in the negotiation context. And if this is what you do for a living, and if you're in sales, or if you're a full-time negotiator, it's some of these authors, Voss, or even the folks in Getting Yes will tell you, well, every day you're involved in a negotiation. Of course you are. You negotiate for your salary at work, you negotiate a lease or to buy a home. But if you're a professional negotiator, you're going to be looking at these materials and try to adopt your own style by using some of the concepts from these different sources in your negotiations on a day-to-day basis. But what if you don't? If you're not in the business of negotiating high-level bargains on a day-to-day basis, it's very tough to take this stuff and use it. It'll feel uncomfortable. Mirroring, for instance, whether it's mirroring body language, which folks will tell you to do to help people feel more comfortable, or mirroring the actual spoken word, as one of the concepts that Chris Voss advocates. Repeating the last couple of words that somebody says. That will feel very uncomfortable for people if they're not used to doing it. You'll feel awkward. A lot of people struggle with silence. I'll cover that a couple times and how you can use that to your advantage. People want to fill space. Lawyers know that if I'm interviewing a witness or deposing somebody, if I'm conducting questioning and I want to get information out of someone, one of the most valuable things that we can use is silence, just controlling our own behavior and disciplining ourselves not to react and not to respond and not to fill empty space. Ask a question. And if you feel like somebody hasn't given you a full answer, if you don't like the answer, if there's something that catches you off guard, just let it sit there. And that empty space feels awkward for a lot of people, but it feels awkward for the folks on the other side as well. But if you're not used to using that concept all the time, then some of this won't feel natural. That's where you really get an advantage by bringing in a third party, bring in a mediator, a neutral third party to help facilitate the conversation. The caucusing sessions in mediation are very valuable. It allows people, by having somebody else communicate the message to the sides, you separate the people from the instant reaction. And sometimes these instant reactions are really what can cause a lot of problems. Just like running out and filing a lawsuit, and you sue somebody for breach of fiduciary duty, and you put all these allegations of what the people have done wrong. Once that's out there and it's in the public record, and there's a lawsuit on file, sometimes it's very, very difficult to get people over those statements that are made in a lawsuit, and they're stated for a particular purpose. Sometimes you're just trying to fill elements of a claim. It's very difficult to get off of those concepts and then bring people back to negotiating at a reasonable level. This is why, with a lot of the concepts that we read in books or theories on negotiation, having a third party, a professional mediator who does this on a regular basis and is used to doing it and is comfortable with these concepts and can help coach the parties on how to maybe use some of these concepts to their advantage to bring the parties together, really offers a lot of advantages. And it can also help people get over what they think is awkward behavior. I've talked about some of these issues already, issues that make the business divorce unique. And you would think in a great economy right now that most businesses aren't struggling with these issues, but I can tell you that both in our law practice and our litigation practice and even non-litigation, breaking deals up, putting deals together, but dealing with disputes that arise in the litigation practice and in my mediation practice, this is probably the thing that I see most often. Call it a shareholder dispute, a partnership dispute. It could be medical practice. I've got an accounting practice. I've got some other services I won't identify because it probably will make it almost too obvious. But this is something that in my practice, at least here in our firm, we see this on a regular basis. And again, it doesn't matter how good the economy is. These are issues that come up. These some other additional unique issues that we face in certain professional contexts, dealing with patients. Again, I mentioned I was involved in a really it was a very negative type breakup. It involved several physicians. I think there were 5 involved at the time. They were, there were allegations, I'll say, that people were shutting off the power to facilities when there were scheduled surgeries in an ambulatory facility. Pardon me. You have duties to your patients. The lawyers have duties to your clients. If you have one business partner that locks somebody else out of information, this is very common. Locking somebody out of the financial resources, bank accounts, locking somebody out of information. I was involved in another dispute. It was another medical. It wasn't doctors, but it was a healthcare related practice where the main operating account of the company, the account from which the payroll, when it was deposited into another account, a bunch of bills were outstanding. One of the partners went back and forth trying to lock each other out of the business and take control. One of them ultimately went to the bank. Some of the banks, some banks respond differently than others. And there's one bank that was notorious in town for just being, in my view, very extreme and difficult to work with. And the bank shut off the account access for everybody. And like essentially they couldn't close the account because there was a bunch of money in it, but the bank shut down the account and there was a bunch of outstanding bills. There was payroll to be paid on Friday. And we find out on a Wednesday that the bank will not release any transactions on the bank account until both of the disputing partners gave the bank a document in writing. Again, I'm not sure the bank had legal authority to freeze several hundred thousands of dollars, but that was the situation we're dealing with. You have control of the business that occurs during the business and after. Sometimes as you're breaking up a business, you have to deal with business debts, personal guarantees, security interests. Who uses what equipment more often? Who's going to take over a lease or an operating facility? Do people keep their own equipment or do they have to leave? If you have outstanding issues, for instance, with, again, in medical, we see a lot where there's a lag time when services are performed and when you get paid because there's delays from the insurance company or delays from Medicare or Medicaid. Then we see audits that come back or further questions on billing. Billing has to be coded properly. And if you're in the middle of a breakup and you don't take these issues into account, you can run into a lot of problems. You can leave money on the table, and you can get into a situation as well where you're not meeting your obligations, whether they be financial obligations or your duties to your clients and patients. This can create a problem. Some of the other issues we see is, again, business records, patient records. I've listed some up here, non-compete issues. If one person's leaving a business and say it's a business practice, a medical practice with 10 physicians, and they've agreed to non-compete provisions. If one leaves because of a dispute in the business and sells their interest, are you still going to be subject to non-compete covenants? How is that going to apply? How are you going to deal with patients and solicitation, deal with referral sources? These are all issues that need to be worked out. You do not want a court making these decisions because the court's going to decide on a bright line rule. And most of these cases that go and get decided by a court end up in potentially a judicial dissolution scenario, and everybody suffers. I like this quote here from Abraham Lincoln. Do I not destroy my enemies when I make them my friends? This was reportedly said by Lincoln during the Reconstruction phase when he was trying to bring the Union back together, and people were giving him grief about his policies towards what they saw as the rebellious South. And I think this is a good thing to keep in mind is when you're in business with somebody and you have a breakup, consider some of the ideas that we talk about today, and staying out of the fight and trying to bring some type of common ground together. So how do we initiate the negotiation? Another cool quote here. I have a few of these in here. The greatest victory is that which requires no battle. That's what we're going to try and do. We're going to try and, the common, phrase win-win, Stephen Covey, or getting the yes. Sure, we want to win-win, but what we want to do is we want to satisfy everybody's interests as much as possible while we stay out of litigation. Of course, I talked earlier about having an agreement where you'll agree to negotiate or mediate as part of a dispute resolution process, and it requires all the parties to do that. If the other side simply refuses to abide by that agreement, we've even gone so far as you could file an action, but make it I recommend a very vanilla complaint. but filed a complaint for declaratory relief to compel the parties to pursue the remedies that are in the agreement that they all signed and agreed to. If that's a partnership or some other type of operating agreement, and then bring the parties into the mediation. You're required to do that. Cooling off periods I talked about earlier. If you don't have something like this, then you can simply suggest it to your counterpart. And I'll start using this phrase. We talk about your opponent, we're talking about the other side. But as you start working with the other side, even my opposing counsel in lawsuits, I want to refer to them as my counterpart, essentially. And I was in it was a very contentious. It was a divorce case. It was a domestic dispute, but it involved the business. And I'm not a divorce attorney. I've been involved in several of these cases, but usually it's where there's a high value asset involved or several assets. And so I came in to help counsel the spouse and the divorce attorney on business issues, on how to deal with a business breakup. And then there was another attorney who came in on the other side. He and I had developed an excellent rapport, and I considered him my counterpart. He was my counterpart. He represented the other side, but he and I were both looking at things from a very similar perspective on how the business should be divided in a way that would maximize the value for both spouses without destroying the business. So try to look at the other side as your counterpart as much as possible. Look at the mediation process as a collaborative type process, no matter how difficult it is. Again, emotions that are in play. But if you can try and approach it from that perspective, it will help you try to get a resolution that at the end of the day is going to be best for you and for your client. And that's the goal here. The goal is to try and get the best resolution for you and your client. And that's probably not going to happen in a lawsuit. What if you can't get the other party or counterparty to sit down and negotiate? What if they just simply refuse to talk or won't agree? I suggest you go to, for instance, one option is go to a trusted intermediary. In one issue that I had, everybody had the same accountant. Both of the partners in this practice had used this accountant for their business, and they also used it for personal. And the accountant was able to help bring the parties together. And the accountant wasn't a certified mediator and didn't do that for a living, but everybody trusted the input of the accountant. And so the accountant was able to help facilitate the conversation, at least bring the parties into the same room. And of course, if we're in a mediation, we often start in the same room, not always. Folks are moving away from that, but then break off into caucuses. But you want to get everybody together. Similarly, if you're having a hard time, but you want to start that process, you could reach out to someone, a qualified mediator, and ask the mediator to maybe have a discussion. Most folks, I'll certainly do that and sit and talk with people for an introductory type period and explore what options may be available for a resolution conference, not necessarily the options for resolution, but explore what we might be able to do for a conference, whether we do that by Zoom or we do it in person, what that process looks like. I think most professional mediators, certainly I will, you can call me and I'll be happy to have that discussion. And there's no charge for a discussion, like just talk about the concepts a little bit and try and at least get both parties to agree, okay, so basic ground rules, here's what we're going to do. These are the folks that are going to be present. And we need to talk, we need to work through some of these issues. For the business divorces, I recommend you have an agenda. Go into to your negotiations with an agenda of items that you need to cover. That'll help you from overlooking things, and it'll also help you tactically as you're involved in those negotiations. Again, I mentioned here lawsuits. When people read lawsuits, especially when laypersons read lawsuits, they can be very harsh. And lawsuits, the other issue is sometimes initial statements in a mediation. It seems to me in the last since COVID, things have become a little bit more inflammatory, where parties used to get together at a mediation, you have a joint session together with everybody and people would explain their side. Sometimes you have a blow up, but usually both sides try to explain their positions in a respectful and courteous way. People hear things they don't like, but that's pretty common, early in any type of dispute. But lately it's gotten a little bit more inflammatory. So maybe we want to try and stay away from anything that's going to really inflame parties, and try to just get them start discussing about what's important, discussing what the issues are. So here's some tactics you can try. Now we're going to kind of get into a little more nuts and bolts of things that you can use, language that you can use if the other side refuses to negotiate or won't discuss interests, or just simply shuts the door or won't return your calls and whatnot. First you can try different language when you're talking. Schedule time to work out our differences. Let's schedule time to have a discussion. Let's have a conversation about whatever the issue is. Some of the tactics that are described, Chris Voss refers to this a lot in his book, is trying to label the other side's position. And he talks about labeling and doing an accusation audit when the other side is particularly emotional, which happens often in these contexts. You want to break down that emotional reaction before you can really start to have a serious discussion. And one way to do that is to use a phrase, it seems like, or feels like, or I get the impression that you're very upset with me, or it seems like the business isn't moving in the right direction. It seems like we really disagree about these issues and how to handle this. Something that I used recently, actually, with a business colleague that I was surprised was pretty effective. I had gotten a couple terse responses from somebody, and I didn't quite understand it, and so I was emailing, and I said, I feel like I've done something to upset you. And I just let that, I said, I don't know what that is, but I feel like there's something I've done that to upset you. And then I got a response, and we ended up having a phone call. We kind of put the issue aside, and then we were able to move on from that. So if you can get your counterpart to open up, don't view trying to discuss, negotiate, work through issues pre-litigation or outside of litigation, don't view that as weakness. View it as a way to potentially preserve components of your business, or components of your client's business, preserve the best pieces, divide up the pie in the best way possible without destroying it, and also consider the long-term relationships. Even if you break up, two lawyers who work together for a long time and have a breakup, they may want to still have the opportunity to refer cases back and forth in the future. So if you can, the old adage of not burning bridges, this is where this starts, is the opportunity to separate without destroying each other. And again, sometimes having a neutral third party help with that process and bring the parties together can be beneficial. I always suggest to people, consider this before it's imminent. Even if you're having problems, consider a settlement conference, consider some type of mediation or some event to bring people together. Maybe even see if you can salvage your business or salvage main components of the business. And of course, if the other side still won't listen, this is where you get into what the sources call the BATNA, your best alternative to a negotiated arrangement. We come back to the BATNA a lot, your own and the other sides, knowing a little bit of research, understanding the issues, and understanding that just versus some type of conference where you can discuss issues, going into litigation is expensive. What I always tell folks is, add up not only the monetary expense, but how much time, how much resources it's going to eat up, whether it's you individually or people that are working for you that you have to pay. It's time, it's resources, it's money, and then there's an emotional component. There's a hostility and a frustration that hangs over you, and it can hang over you for a couple of years in litigation. You have to add up all those costs to figure out what the cost is going to be in litigation, to really figure out if that's a better alternative to at least exploring settlement options. Most reasonable folks, most reasonable attorneys certainly will explore these options more and more now. I think folks, even very early on in a dispute scenario, will explore mediation options or some type of settlement options. A lot that I'm seeing right now are very early, either pre-lawsuit or very early in the lawsuit process. People just don't want to be in the lawsuit. And there's another I saw recently, the vanishing trial, I think was referred to. And there are some attorneys out there, you'll see some and talk to some. We take cases to trial. We're getting ready for trial. We don't talk. We don't negotiate with the other side. And I suggest that if you're in business and you're dealing with an attorney who wants to take your case to trial, consider whose interests they're serving. Are they serving your interests? It's all well and good to prepare a case as though it's going to go to trial. That helps you be prepared to deal with issues in the case. But going to trial, for attorneys who've been through trials with clients, whether you win or whether you lose, when you sit down and you take a look at it after the fact and look back and figure out that was a good experience. I have clients that were very, very bitter after winning trials. And I have clients I've been able to maintain friendships with after losing trials. It's not a pleasant experience. All right, so we're going to move into our next topic here. I like some of these points that we'll talk about. This is about maintaining your Zen and managing your emotions. You have to be conscious about this, first of all. You have to decide, I'm going to be in control of my emotions. I'm going to be in control of my behavior, which is the outward expression of my emotions. Some of this is a little mushy, but there's some stuff that really works. I'll tell you right now that clients that I talk to, even if they're going to testify in a deposition, testify in trial, go into a mediation, when I deal with parties, when I'm representing somebody in particular, in any of these situations that are stressful, just stopping and taking a few breaths. If you have to do public speaking, this works. If you don't like getting up in front of a crowd and you have to get up in front of a crowd and talk, before you get up in front of the crowd, sit back. And there's a concept called box breathing. It's 4, 4, and 4 is one concept of box breathing, or 4, 4, 8. It's how long you inhale for, how long you hold for, how long you exhale for. You can read up on this if you're into meditation, if you're into yoga. Wim Hof, I've been big into the Wim Hof method. You can check out Wim Hof on YouTube. He's the guy they call the Iceman. He has a breathing concept. It has been shown to, breathing alone has been shown to change people's physiological responses. If you are in a discussion on the phone or in person with somebody and you know it's going to be stressful, or if you are in a discussion, somebody says something that's going to typically set you off, or it's something you would normally react to, if you can train yourself to stop and take a few deep breaths, 4 in, hold for 4, 4 exhale. People are going to try this. I'm sure it's like one of those things that hopefully as people are listening or watching, you try this and notice your heart rate. Notice what happens to your breathing. If you really want to have fun with this, if you have one of those little cuffs that monitors your blood pressure, you can actually manipulate your breathing and change your blood pressure. So if anybody's out there going to have a physical anytime soon for life insurance purposes or something else, and you want to manipulate your blood pressure, you can do that through breathing concepts. Mirroring is another very effective technique. Not only language, I think sometimes this can be overused by people who read about it a little bit, but it's this concept that animals and people innately have an attraction to other people that are like them. And so even movements in the same way. So if somebody leans in, you lean in. If somebody sits back, you sit back. But you want to do this in a subtle way. Again, it could feel a little bit awkward. But some folks take it even further. You'll have some advocate for paraphrasing what other people say to show that you heard them. So you hear what they say, you paraphrase it. You could use the concept of, the one concept of using, it seems like, taking what they say, it seems like you feel this way, or just to keep people talking, add in with your silence. If somebody answers a question, yes, I feel like you've been taking too much time off, and you could mirror their language. I've been taking too much time off, or just the last couple words. Voss, I think, says use the last 3 words, time off or too much time off. And that will get people talking. And as they're talking and they're very aggressive in their approach, it will help as they're continuing to expend energy on their discussion. It'll help calm things, and they'll feel like they're making their point. You give them the sense that you're listening to what they're saying, you're not reacting, and it sets you up to have a better reaction. Again, all of this is designed not to pacify the other side. It's designed to get you the best option in a settlement scenario or in a dispute scenario. The getting to yes, I think it's, or the getting past no book talks about going to the balcony. I have that as a step in resolving disputes. One of the steps is to go to the balcony. This is the idea of kind of stepping away from an inflammatory statement. If you can use an excuse to leave the room, go get a drink of water, make a telephone call, say you need to talk to somebody, figure out an excuse to take a break or at least just be silent. It's this concept of what they call going to the balcony, of just kind of stepping outside and observing as a third-party observer. Again, a huge advantage here if you're in a mediation, because you've got an intermediary and you're in a caucus session, you're in separate rooms. So this is sort of built into that practice. Some other concepts, when you hear, again, I talk about mirroring and labeling. Labeling is this idea of taking the concepts that, taking what somebody's saying, especially if they're expressing frustration or anger or some emotion, and putting a label on that and trying to get them to continue discussing it so we get past that issue and then work towards a point where we're both focused on interests moving forward. Managing your behavior, again, you can do this first by your breathing techniques, slowing down your speech. One source says you use the FM DJ voice, talk with a downward inflection, and try to calm people and get them to talk or listen at a more calm pace. Slow down your talking. It slows down your own thought process. I won't do that for the entire time, but that's the idea. Also, making a conscious commitment when you walk into a discussion that you're going to listen, and you're going to listen more than you speak, especially in the beginning. Sit and try and just capture concepts. I read this years ago, and it's worked. I used this when I was younger in job interviews and in talking to people. You hear a lot about making eye contact. Beyond eye contact makes a lot of people uncomfortable, especially if you're staring. It's like, okay, what else do you look at? Do you look over people's heads? Do you look around? How do you break eye contact? One useful, I call it a trick, I suppose. It's not a trick, but one useful way that you can pay attention to what people are saying and break eye contact occasionally is to look at their mouth. And by looking at their mouth, you still follow what the person's saying, and it conveys this message to folks that you're really focusing and paying attention to what they're saying when you watch their mouth. There's a psychological, they've done studies on this, and it seems to work. Of course, I had one client who was very good with, who had been trained in sign language, and that one particular, he was a very unique character. He was big in the motorcycles. He actually, I ended up getting my motorcycle license with him. I'm still friends with him to this day. But years ago, when I first met him and I was talking to him in a meeting, I represented him in a lawsuit. And as I was looking at his mouth, he asked me, he said, "Do you have a hard time hearing?" And he picked up on it, but it was because he had been trained to work with deaf folks and had been trained in sign language. But most folks will just take that as you're really paying a lot of attention to them. Commit to being flexible in your mindset and in hearing what the other side is saying. And then throughout the process, while you're in a negotiation and a mediation, continue. We do this if you ever go through trial training when you're in trial. Always monitor your body language, do self-assessments. If you have a counterpart, somebody that you're working with, okay, how is my tone? How is my delivery? Is everything, am I portraying the right image? Don't just wing it. These are things that people think about, what type of approach they're going to take when they go into these scenarios. These are some of the concepts on once you get into the settlement conference. How do you get people past not wanting to negotiate on fair terms and not wanting to negotiate over interests and maintaining hardline positions, and bring them to a state where you can actually work out a workable deal. We talked about not reacting, not reacting to an opponent's bad behavior. If somebody says something inflammatory, takes an extreme position, uses an insult, if they offer a bargain that you don't like, take an extreme position, what are your options here? You can retaliate, and that's just going to damage the long-term relationship. You can call them names or file a lawsuit or make accusations against them. Well, you don't think I'm being fair. I think you're stealing. That's not going to accomplish anything long-term. We all inherently know that, but you need to hear it and think about it. What's the other option? You can break off you say, okay, I'm not going to do this. And we see that a lot. I've seen that a lot in a lot of mediations. I've had to pull people back in. We're not going to do this. Sorry, we're leaving. We're done. We're getting up. people pack up their books, especially with the in-person. But now we see it with Zoom. They don't shut off the camera. They want to pack everything up. Again, you're not going to accomplish what you're there to accomplish by doing that. Of course, you could just give in to the other side. If you give in, that while that may be expedient at the time, later down the road, you're going to feel like you got a bad bargain. You're going to feel duped, and that's not going to result in a long-term solution either. So the idea here is not to give the other side necessarily what they want. The idea here is to figure out a way to create a bargain that works for everybody. It's very important, again, to understand your BATNA when you're negotiating with the other side, or negotiating with a counterpart, or with business partners, or with their counsel. If the negotiations don't work, what's the best alternative? Where does that leave everybody? If the business is unmanageable the way it is, if you're in one of these situations where a bank account is frozen, and you're going to blow your payroll, and your entire business that's profitable is going to go up in flames. If you've got people that are shutting off the electric for each other, that are sending out nasty emails anonymously to somebody's spouse, I've seen all kinds of crazy stuff in these situations. That's not a long-term solution. And understanding not only what your best alternative is, but what your counterpart's best alternative is, and reminding them of that is incredibly important as you go through this process and work through the issues. After we sit down and we hear what the other side has to say, we've absorbed that, we've prepared ourselves for not having an emotional response. We let them sort of build themselves up and work out all of those initial inflammatory emotional issues. Now we need to figure out how we can weave ourselves into a negotiation. Here we use the term negotiation judo. That's not my term. It's actually the term from, I think they use it in both Getting the Yes and Getting Past No. I've seen it a few times. It's the idea of taking the other side's aggression, take the other side's assertiveness, and trying to step to the side and listen to them, but then steer them back to a point where you can both find something to agree on, not necessarily giving into their position, but you want to get an agreement that at least you understand their position and where they're coming from, so you understand their interests, and you try and get both interests aligned. Another, I think it's Voss's book, calls this tactical empathy, acknowledging points on the other side. It doesn't mean that you're giving in. It's just acknowledging the points, but you acknowledge points, you agree on points without necessarily conceding points in negotiation. You could acknowledge that somebody feels angry and feels cheated, feels slighted for whatever that reason is, acknowledge that a solution needs to be found. You're not giving up anything. You're just acknowledging points for the other side. You can use questions to elicit a yes response. This is a common sales technique, but it can, in some ways, acknowledging someone's point, paraphrasing it back to them. What Voss suggests is getting somebody to say, that's right. If not that you're right, but getting somebody to acknowledge that, yes, you get the point that I'm trying to make. I've seen a lot of these situations where people are upset about emotions. They feel slighted. And a lot of times it has little to do about the economics and about the business itself. It has more to do about somebody feeling like they've been disrespected in the business. That's probably one of the biggest things I've seen in a breakup, is where business partners, they're making money, the business is successful, everything's going well, but one feels slighted by the other, and that can create a lot of problems. Another tactic that you can use, if people continue with their extreme positions, you can either take a position of, how am I supposed to do that? That's one of the questions that is used. Just saying, okay, you've said this and this, and I feel like this is what's going on, and I can use this if I'm in a mediation and somebody says, okay, this is what I want. They lay down their terms and it's take it or leave it. Okay, how are we supposed to do that? Let's reality test this. Let's take what you've proposed and actually put it down. Let's write it out if we need to. It's okay, how do I accept these terms, or how do I go back to my advisors, or go back, if you're an attorney and you're representing your client, how do I take what you're proposing? How do I go sell that to my client? There's an example with in the 1973, at the end of the Israeli-Arab conflict, over the positioning for the Suez Canal and territory, a story about Golda Meir, who was negotiating with her counterpart in Egypt, and said, what would you like us to do? Or, what's your proposal? And the counterpart, wanted them to withdraw from the Sinai Peninsula and Golan Heights, and northern Israel and give up all the territory that they had and essentially walk away. And so she repeated it back. She said, okay, if I give up this and I give up that, okay, what else do you want? What else? And she listed it all out. Said, okay, I'm going to go back to my constituents and I propose that to them. What kind of reaction do you think I'm going to get? And supposedly the story goes that her counterpart started laughing. And then from there, they were able to finally kind of broke down that defense, realized as it was laid out how ridiculous the position was. And then they were able to move on to an agreement. Negotiation judo. I had to throw this in here. This is my daughter. This is maybe a suggestion. If the negotiation judo doesn't work, then you can use maybe a little bit of regular judo. The fellow that she's, this is Sensei Shinhiro. He was a Japanese national champion. And this is my daughter, who's all about 45 pounds, taking his weight and using it to toss him over her shoulder. So, you know, there's other options, but hopefully we don't come to fisticuffs. But it's that idea of taking the other side's aggression and assertiveness and trying to figure out a way to channel that in a way that serves your interest. Next, after we were able to get the other side on our side, kind of move them in, you know, side by side, now we want to reframe the issues. And one good way to do this is when people take a position you don't agree with, instead of saying, okay, I hear you, but try, I hear you, and repeat their position, paraphrase it, and then continue with an and statement to try and tack on as though everything is sort of running together and you're working side by side. If someone really has ridiculous or extreme positions, you can test again, do reality testing on their positions to bring them into their interests and ask questions like, you know, how are we supposed to do that? How do we implement that? What about that makes it fair? If we were to do that, how would we make it work? What does that look like? Let's lay it out and test that and see what that looks like 2 months, 6 months, you know, 12 months from now. And again, once you ask those questions, don't be afraid of the silence that follows. Let the other side answer the question. If they've given you a ridiculous position, say, okay, let's assume we take that position. That seems to me to be an extreme position. How is that fair? Explain to me why, if you were me, that's a good position that I should agree to. And then let them fill the silence. And that will often help people realize themselves, bring them, you're not going to convince them of your point, but you want them to be convinced of the point. And people are most convinced of a point when they come up with it themselves. Another great piece of advice, something that I really like, especially this works great for in a mentor-mentee type relationship or with younger lawyers, is, you know, if you're dealing with somebody a lot more experienced, especially if they even seem maybe a bit condescending to you, ask them for advice. Okay, what advice do you give me? How do I go back? How do I take that to my client? If I'm the mediator, I can ask somebody, okay, you've taken this position. I can go back and I can convey that message, but I have a feeling I know what they're going to say. Help me convince them that this is a good position. How do I go over and how do I convince them that this is reasonable and something that we should explore? Give me my talking points. Give me some advice on how I can make this work. Little quote from Yoda up here. Many truths we can cling to depend on our point of view. That is ultimately true in settlement negotiations and in litigation. A lot of the views that we have and our beliefs about what is fair and what is right often depends on our point of view. So if we can just get the other side to explore, get our counterpart to explore a different viewpoint, we can start to influence that viewpoint, which is ultimately what we want to do. And then, you know, by again using the concept of the BATNA, try and bring the other side to a position where you're agreeing, okay, this is the path that makes the most sense. It's better than a litigated issue. It's better than fighting this out in court, which is going to result here in a bad situation. Build your counterpart a golden bridge. Give them a way to agree to something that actually makes sense for all the parties. And I put at the bottom here, avoid the temptation to rub the other side's nose. Don't try to take advantage of your counterpart. Don't try to humiliate your counterpart. Try and make a solution that everybody feels good about. Because what you don't want to do is you don't want to end up even with a deal where you feel like you got the best deal of the day, but it's one that won't be carried out for one reason or another. We're kind of late in our slides. I have a lot of material in the slides. It's a couple minutes left in our webinar. The last step here on breaking down defenses is making it hard to say no, using power to educate. Again, this is, if the other side is still refusing to do a deal with you, reminding them, okay, if we don't work out a deal, this is what's going to end up happening. This happens frequently in mediations at the 11th hour. We see a scenario. It's like, okay, what is your alternative here? If you don't cut a deal now, what do you walk out with? And that scenario often doesn't look good. There's an example in something I was reading about a power plant in Texas that was right outside the municipal limits, and the town was trying to get the power plant to pay more in taxes. It didn't have any authority to cause the power plant to pay taxes, but they or at the level that they wanted. But the town had the authority to annex the plant into the municipality on a vote, and could do that and then cause the plant to pay taxes at the same level as everybody else in the town. And in negotiations with the power plant, once that was pointed out, once they pointed out, look, we know your alternative here, and we know our alternative because we've done our research before we came in. We were prepared. We know what the alternatives are. If we don't reach a deal today, then you force us into this other position. It's not a threat. It's just informing the other side that, let me tell you what's going to happen if we don't reach something today. We're going to be in this other situation, and it's not going to work out as well, for you or for maybe for both parties. I have a whole set of slides, one by one, on dirty tactics and countermeasures, which is our last point. Want to hit a few of these that I think are, particularly ones to watch out for, and we'll wrap up here. Generally, if you're in a stressful situation, if you don't like the room, if it's too hot, if you can't get something to drink, if there's no private area to caucus with your attorney, with the mediator, don't be afraid to say so. Change the circumstances. There's some other concepts. If you go through these slides, and maybe what we'll do is we'll do a follow-up. I thought maybe this would be an hour, would be long, but we actually have quite a few particular situations here that we've covered. And I want to see if there's any questions. I don't see anything that I hit on the slides, but if there are, please ask me afterwards. But take a look. Everybody's got the slides here. Go through some of these points that I've hit, especially, I talked about refusal to negotiate and some of the counter attacks or the countermeasures you can use there. Personal attacks, again, the key here is don't react. But if somebody continues on personal attacks, this is where an effective mediator or your lawyer can really call this out, especially a mediator. Like, look, let's lay some ground rules from the beginning. We're not going to make personal attacks. We're not going to do this. Separating the parties and having a little bit, that creates an instant lag time between communications. A lot of research has been done on the fact that email has created more inflammatory communication because people are able to send it instantly. I have discussions in here, little points, bullet points and pointers on extreme positions. And now I think we hit 1 o'clock. I want to make sure I honor everybody's time. If you need CLE credit, please let us know on that. Go through some of these last ones. Give me a call. Let's talk about any that you have a question about, or shoot me an email. And I'll be following up on some of these concepts. Maybe we'll dedicate some time specifically to this in the next presentation, and we can put it in different contexts. So here, finishing with this final quote here, the idea here, show your skill set not by trying to win the battle, but essentially by trying to reach a resolution without having to go to battle. In different words of the famous Sun Tzu. My contact information is below there. Again, reach out for, my mediation calendar is available online, or you can shoot me an email. I'll be happy to talk about mediating a case with you, or if you have any other questions, feel free to reach out about any of the material that we presented today, and have a great rest of your afternoon. Thank you.